The legal war between 23XY Racing, Front Row Motorsports, and NASCAR isn't just heating up, it's boiling over. And this time, the outcome could change how the sport operates for years to come. At the center of this fight, charters, the golden tickets of the NASCAR Cup Series. These licenses guarantee entry into every race, provide access to significantly more prize money, and give teams something critically valuable in motorsports: leverage. With a charter, you're in the show. Without one, you're scrambling just to qualify, making less money with far less stability. So here's what's going on. In late 2024, just before the 2025 season began, 23XI Racing and Front Row Motorsports found themselves in the middle of a legal brawl with NASCAR over charter rights. The trigger was a rule change buried in the updated charter agreement, a new clause stating that if a team signed the charter contract, they would waive their right to sue NASCAR. In other words, if you want to race under a charter, you lose your right to challenge the league in court. 23XI and Front Row refused to sign it, but they also didn't walk away. They took NASCAR to court, and they won, at least temporarily. A federal judge, Kenneth Bell, sided with the teams. He granted them a preliminary injunction, meaning they could continue racing with the charters they already had, 3 each, while the larger legal battle played out. The court also allowed them to complete a major transaction, buying those charters from Stewart-Haas Racing. So, entering the 2025 season, both teams were operating under 6 charters total. That gave them locked-in entries, sponsor stability, and the ability to plan for the year like any other team. But NASCAR wasn't done. They immediately appealed the injunction and pushed for a second hearing, which brings us to where we are now. In June 2025, 16 races into the season, NASCAR is back in court, this time trying to strike down the injunction and reinstate the no lawsuit clause. This latest hearing didn't cover the entire antitrust case. It focused solely on one question: is it legal for NASCAR to force teams to give up their right to sue as a condition of doing business? NASCAR's lawyer, Chris Yates, argued that this wasn't anything unusual. He said similar provisions have existed in past contracts. No one objected then. Why now? According to Yates, this is standard legal protection, not a power grab. But the team's attorney, Jeffrey Kessler, fired back. His position was clear: removing the charters would cripple their operations. These are not just licenses, they're baked into driver agreements, sponsor deals, and internal team structures. Pull them now and the whole thing collapses. The judges, however, weren't easily swayed. They pressed the team's legal team with hard questions. Their central concern? It looked like the teams were trying to play both sides. They refused to sign the new agreement because they disagreed with the release clause, but they still want to keep using the charters as if nothing changed. One judge put it bluntly: "You can't have your cake and eat it too." In the eyes of the panel, this was a contradiction. If the teams didn't agree to the terms, they shouldn't be entitled to the benefits. But here's the catch: the court hasn't made a final decision yet. That could come in a matter of days, or stretch into the next few weeks. And the implications of their decision are massive. If the injunction is overturned, 23XI and Front Row Motorsports could lose all 6 charters. Those assets could be returned to Stewart-Haas Racing, reassigned, or taken back by NASCAR entirely. In that scenario, the teams would be downgraded to open status. Here's why that matters. NASCAR limits the Cup Series field to 40 cars. Each weekend, only 36 spots are guaranteed. Those go to teams with charters. That leaves just 4 spots open. And when more than 40 teams show up, which happens often, those open teams have to qualify on time, miss the cut, and they go home. No race, no payout, no exposure for sponsors. Being an open team is a risk, and sponsors don't like risk. Neither do drivers. Take Tyler Reich, for example. According to documents filed in court, his driver contract is conditional. It depends on the team maintaining a charter. If the charter disappears, technically, so could he. Maybe not mid-season, but definitely before 2026. And sponsors? they're even more sensitive to uncertainty. They want guaranteed TV time, consistent branding, and a team that can promise a full season presence. Without a charter, all of that becomes unstable. It's not just a performance issue, it's a business crisis. Zooming out, the case reflects a deeper, long-standing tension between NASCAR and its teams. The current charter system was introduced in 2016 to bring structure and long-term value to team ownership. In many ways, it worked. Charters created a secondary market. They became assets, some selling for over $25 million. Teams started building around them. But the flip side is that NASCAR still holds all the keys. They decide how charters are distributed, when contracts are updated, and what rules govern ownership. Teams argue that they're being treated like subcontractors in a business they help sustain, and yet they have little say in how it's run. This legal fight is about way more than just 6 charters. It's about who controls the sport. Back in the courtroom, the most recent hearing was held in Richmond. The 3-judge panel didn't hand down a decision that day, but they did urge both parties to seek mediation, to try to settle before the case explodes any further. Still, most legal experts who attended said the tone of the hearing leaned in NASCAR's favor. And if that prediction holds true, if the court lifts the injunction, the effects will ripple far beyond 23x1 and front row. It will send a message: challenge NASCAR's authority, and you risk your position in the sport. But if the court upholds the injunction and lets the case proceed to full trial in December, everything changes. That trial would force a deeper review of how NASCAR wields its power. It could open the door to new team protections, different contract structures, and a complete rethinking of the charter model. For now, the uncertainty continues. Teams like 23XY and Front Row are racing while looking over their shoulders. Every contract, every sponsor call, every strategy session is touched by this legal cloud. And while drivers focus on the track, the executives are preparing for whatever the court decides next. Should NASCAR win, teams may need to adjust how they negotiate, perhaps even how they exist. The league will regain full control of its structure, and future disputes might get snuffed out before they ever reach a courtroom. But if the teams win, NASCAR's charter power could be cracked wide open, and the teams might finally get a stronger voice at the table. In a sport where milliseconds matter, it's rare to see a battle where the outcome takes months, maybe even years. But make no mistake, this courtroom showdown is just as intense as anything on race day. Only instead of engines and tires, the tools are legal briefs and injunctions. And while fans might not see the full impact today, what happens in this case will shape the way NASCAR operates for the next decade. So here's the question: should NASCAR be allowed to protect itself with a clause that stops teams from suing? Or are the teams right to fight back, even if it means putting their entire future at risk? Let us know what you think in the comments, because the next green flag in this saga won't be on the track, it'll be in a courtroom. And when that flag drops, the future of the sport will be riding on the verdict.